Welcome to our program on immigration and you. I am your immigration attorney Michael Fulwani, and today my law partner David Nachman is not available because he's traveling, so I'll do the entire show by myself. First of all, a very happy Diwali to all of you. I hope you enjoyed the sweets, the fireworks, and romantic events or whatever made you happy. So, with that, also I want to start today with the cutoff dates for the month of December 2015. Now, before I start telling you about the cutoff dates, remember that from last month, the Department of State is now sending us two separate bulletins. One bulletin is the normal bulletin, which shows you the cutoff dates, how they have advanced or sometimes gone back. And the second bulletin that started only last month is something new, where they decided that certain people who are living here in the United States and are eligible for applying for adjustment of status, except that their visa number is not available, will be permitted to file their 485 application somewhat earlier, in some cases a year or some cases a few months. So that is a second bulletin that is for the people that are here living in the US and eligible for adjustment of status, and they can file the 485s even if their visa number is not available. The good thing in 485 filing is that upon filing of the 485, the main applicant, for example, if the husband, he gets a permission to work, maybe travel as well, and the wife or the husband, spouse can also get permission to work, and in many of the people, they are not eligible to work, especially the spouses. So this is in a way good news, and we had explained previously that in the past this thing started because the number of visa numbers of a lot of visa numbers were not being used by the consulates and the immigration service, so they started this process under which they will probably not lose any visa numbers. Okay, so let's start giving you the information for the month of December 2015. So here's the bulletin for December 2015. In the family preference categories, the first preference, which is for the unmarried sons and daughters, unmarried over the age of 21, it advances by 5 weeks to April 1, 2008 for all countries. The family 2A category, which is for the spouses and children under the age of 21 of green card holders, advances by 4 weeks to June 15, 2014. The F2B category, which are the unmarried sons and daughters over the age of 21 of green card holders, advances by 3 weeks to March 1, 2009. The family third preference, which are the married sons and daughters of the US citizens, advances by 2 weeks to July 1, 2004. And the family fourth preference, which are the brothers and sisters of US citizens, advances by 3 weeks to March 22, 2003. In the employment preference categories, the first preference, which are priority workers, is current for all the countries. The employment second preference, which is for the advanced degree holders, is current for most of the countries except India. India, it's a good news still for India, advances by 10 months to June 1, 2007. And the employment third preference, which are the professionals and skilled workers, advanced by 3 weeks for India to April 22, 2004. For most of the other countries, the employment third preference, which is interesting, is current as of September 1, 2015. And the employment fourth preference, the special immigrants, which involve the priests and religious workers, is current for all the countries. And the EB5 investment category for the $1 million or $500,000 investors is current for all the countries. Now, one of the things that we always repeatedly say is the rule of cross-chargeability. In other words, if you are born in India, you are under the Indian quota, and in the EB3 category still is 2004, that means another 10, 12 years of waiting. But if your wife, for example, is born in another country, maybe in Pakistan, Bangladesh, Sri Lanka, Nepal, any country, then you can take the priority date of your spouse's country of birth, which is almost current. So this is important to know. And somebody asked me a question that I am not married, and I am in this category waiting many years and years. I'm trying to get married. I said, well, marriage is a lifetime thing, but if you find the right partner and it person was born in another country, you will get a green card within 2 or 3 months. So that's a tip that some people may want to utilize. Now, let us go to the second bulletin, which is for the adjustment of status people. Now, adjustment of status people, as I said earlier, that these are the people for whom the visa number is not available, but in spite of that, these are the dates that if their priority date is on this date or previously, they can still at least file a 485 adjustment of status application. So this is the bulletin number 2. Don't get confused. Bulletin number 1 is people that are in India abroad. It applies to them. This doesn't apply to anybody who's outside of the US. So this is only for people who are living here and eligible for adjustment of status, and their priority date is the ones that I'm going to tell you right now. In the family preference categories, it is May 1, 2009. In the 2A category is March 1, 2015. In the F2B category is July 1, 2010. The third preference married sons and daughters of US citizens is April 1, 2005. And the fourth preference brothers and sisters of US citizens, it is February 1, 2004. Now, in the employment preference categories, all they are current anyway, so it doesn't matter. It's no different between the regular bulletin and this bulletin. The second preference, advanced degree holders, is current for most of the countries, many of the countries except India. India, the date for the filing is very interesting. The date of the filing of the 485 is July 1, 2009. So even if there is a 2-year difference between the regular bulletin and the AOS adjustment of status bulletin, this is very nice and very helpful. The employment third preference, the professionals and skilled workers, the date is for other countries other than India is October 1, 2013, and for India it is July 1, 2005. The other workers category is the same as EB3, and the fourth preference, employment preference, is current for all the countries, and the fifth preference is also current most of the countries except China. China is backlogged somehow. So these are the cutoff dates. I want to tell you the predictions. Now, I am not a Jyotshi, but we get this thing from the Department of State once a while, telling us what should you expect in the coming months. So here is the information. In the family preference categories, they say the family first preference may advance at the rate of 3 to 6 weeks every month. The 2A category may advance by 3 to 6 weeks also every month. The F2B category, it may advance up to a month every month. The F3, the married sons and daughters of US citizens, may advance by 2 to 4 weeks every month. And the family fourth preference, brothers and sisters categories, also may advance by 3 to 4 weeks. In the employment preference categories, the EB1 category is current. The EB2 category, the worldwide is current, as I said, and India, the filing date is at least 8 months difference that you can apply at 8 months prior to. This is about the movement. Advance movement is expected about 8 months every month. Which is very, very nice, because EB2 somehow, I think they are trying to clear the backlog of the EB2 category, and that's why their advance movement probably prediction is about moving 8 months every month. The EB3 category, the world may advance somewhat, and for India, they say that it may continue to advance at the rate of about 3 weeks every month. The fourth and fifth preference categories which are current are likely to remain current for the next few years at least, hopefully, unless there is a change in the law which is being considered. Now, another very important information I want to give you is about the new decision that came from the Federal Court on the DACA and DAPA. But before I do that, let me just tell you about the DACA and DAPA. The DACA 1 provided, this is the administrative memorandum that was issued by the President to grant some reliefs to people who are unlawfully in the US. So the first memorandum they did on a DACA, which was for the children who under the age of 16 came to the US, they went to the school and they resided in the US at least for 5 years. So the DACA benefit was given to them, those who came before 2007. Now DACA, what is DACA? DACA is not a path to green card, DACA is not a path to citizenship. DACA is simply deferring, putting on hold the deportation, and under that also they gave the permission to work to those who qualified for the DACA. Now the good news is for DACA 1 and DACA 2 will come later. DACA 1 people already, lot of them applied, they already got the benefits and now they are protected from deportation. What happens in the future only God knows, but at least they are okay. They can get the driver's license and then they can at least live without any fear and all that. So after that what happens, President Obama comes up with some more memorandums, DAPA and the DACA 2. The DACA 2, almost the same requirements that we said before for the children, except they extended the date to 2010 from 2007 to 2010. So this was a very good thing. And the DAPA, which is for the illegal people who have children who are either citizens or green card holders. So these two categories would have got about 5 million people in this program. Unfortunately, what happened is that the reaction from the Republicans, especially the conservatives, they are very, very unhappy about this. So what they did is they went to the court in Texas, which is the 5th circuit we call it, and that circuit has a jurisdiction over Texas and Louisiana. Now there are 3 judges in that. So basically they have made the decision, but the history of that is, firstly they went to a US District Court and they filed a case against Obama, not against, but case on that Obama does not have a right to grant such memorandums, because it is the Congress that makes the laws, not the president. And this president is doing is not just 1 or 2 isolated cases, he's doing thousands, millions of people, which really is the job of the Congress to do it and not him. So while the suit was filed, simultaneously they also made an application for a temporary stay order, and the judge granted the temporary stay order. And after that, obviously both of these programs did not go further and they have been frozen ever since then. So then the government, the Department of Homeland Security from President Obama's side, they filed an appeal in the higher court of appeals, and they kept on pending for a long time. Finally the decision came now on November 9th, and they went with the previous court and did not make the change. That means the stay order continues. So this is really a bad news. The probable good news from this may be that President Obama is filing now a suit in the appeal to the Supreme Court, and we hope that the Supreme Court may hopefully decide before the President Obama's term is over, and some people can get a benefit. We'll see what happens. A lot of more information on this, but we're running out of time today, and we will let you know the next program, more details. Thank you and goodbye.